This is what we have tried to achieve, that with the consent of the Learned Counsel for the parties, time schedule will be fixed, and the important thing that we have taken care of is that a counsel appearing in a murder case is supposed to be a senior counsel, a seasoned counsel. He'll have many other commitments also. He'll have to appear before many other courts. So what we have done is, through the National Judicial Policy Making Committee, we have taken a policy decision that when a trial is scheduled, a scheduling of the trial has taken place, dates have been fixed with the consent of the counsel for the parties, then a certificate will be issued to the Learned Counsel for all the parties, and that certificate, if presented before the High Court or even before the Supreme Court, the cases in the Supreme Court and the High Court will be adjourned, but the trial will not be adjourned. So this is a fundamental shift in emphasis, that the emphasis has to be on the trial of cases, not on the appellate stages. All those appeals and revisions and petitions, they are a byproduct of that trial. So the trial must take place and at its scheduled time. In this very second step, we have taken another precaution, that maybe on the appointed date, the Learned Counsel falls sick, or there is some other unavoidable commitment that he has to make, some family commitment, or some other unforeseen reason he cannot appear. So right on the day of scheduling, we also get a list of his juniors from him, that in case he is not in a position to appear, then his juniors or his associates will appear. The third step in this is that even if the Learned Counsel cannot make it, even if his associate cannot make it, a counsel on the defense list will be provided to the accused on day one. So if two steps fail, the third step, the defense counsel at the state expense has to be there prepared with the case in advance. So every effort is made that the case is not adjourned for a fault on the part of the counsel or in default of the counsel. Likewise, the prosecutors have been warned in advance that once a case is scheduled, a trial is scheduled to take place, then the prosecutor general has to ensure that all his prosecutors appear on the appointed date, and if, God forbid, for some unforeseen reason, the prosecutor cannot appear, there should be a substitute prosecutor already waiting in the wings. This is the second step. Our first is challan, then the scheduling. The third step is, which is a fundamental shift in our approach. For the last about half a century, somehow, originally it used to be the responsibility of the state to produce witnesses who are to appear on behalf of the prosecution. But somehow, for the last many decades, this thing was not given due importance by the state agencies, and the complainant was to bring witnesses who are to depose for the prosecution. That was wrong. In a state case, the state must take responsibility for the case. So we have undertaken a fundamental shift in this, and we have shifted the burden to where it was due. We have required all state agencies to cooperate and to produce witnesses. Private witnesses as well as police witnesses are to be produced by the police. And we are very grateful to all the inspectors general of the police that they have fully cooperated. There are focal persons appointed everywhere, and a list of witnesses is provided to them, and the police is making sure that the private witnesses as well as the police witnesses, wherever posted in the, are made to appear on the appointed date. The second is the prison authorities. The state, as I said, must take responsibility. So the vans which are to bring prisoners, they should be in proper order. If the vans break down, we'll not spare the superintendent of jail. will take action against him. If he cannot bring him on an official vehicle, he should send the accused on his private vehicle. Whatever be the reason, the accused must be presented before the trial court on that date. So I would request those in charge of the prisons that they must make arrangements that prison vans are in good working condition, and their scheduling, their timing is such that before the court hours begin, the prisoner must be produced before the trial court, at least in these model courts. Then the medical profession. In every criminal case, if it is about hurt or murder, a doctor is involved. And doctors are sometimes posted out, they go to different districts. So it should be the responsibility of the health department to produce the doctor before the trial court. And for that purpose, we have again established focal persons who are interacting with the health department. And the health department, I'm grateful to them that so far they have cooperated beautifully, and all those doctors have been produced before the model courts whenever they are required to testify. The next limb was the reports of the chemical examiner, of the serologist, of the forensic science agency or laboratory, and even those authorities have been taken on board, and they are fully cooperating with our in charge here, and they are producing reports in time. And whenever there is a default, I'm sure those defaults will be looked into by the authorities concerned. So when the case is scheduled to be heard, all the relevant reports must reach the court well in time. So these are different things which we have ensured that the state, number one, takes responsibility for the state case. Number two, because of the scheduling and because of other factors that we have attended to, there is no delay. So delay is being targeted, and that is the approach. And without any change of law, without any change of procedure, we have achieved the miracle that you have seen, and the heroes are sitting here, and we salute them. There's no extra expense involved. You see, all those commissions which were previously constituted to reform the judicial system, they recommended changes of laws, they recommended changes of procedure, but nothing worked. Because it's unfortunate that for the Parliament, probably justice sector is not a priority. There are other bigger things for them to attend to. But justice sector is suffering because of lack of attention of the Parliament. The Law Commission has already submitted about 70 reports to the Parliament and to the Law Ministry for attending to different parts of laws which need attention, which need amendment or substitution by different provisions. But unfortunately, none of those reports have so far been taken up by the Parliament for consideration. So I would say, I would request that as we have taken responsibility on our side, the Parliament and the Executive should also show similar interest in the justice sector, and so that the whole thing can be reformed and it starts delivering. I would also, speaking of legislature, I would say that there are certain laws which need to be revisited. I'll give you an example of the Court Fee Act. In every civil case, an issue has to be framed whether proper court fee has been affixed or not. For that, people have to run to the revenue officials, get documents, present them before the court, deposit court fee, then the other party objects, an issue is framed, evidence is led, and ultimately some decision is also to be rendered on that issue, which again is a subject matter of appeals, and it goes on. A very simple solution exists. You fix the court fee as a general court fee for all kinds of suits. Fix it as 1 rupee or 100 rupees or 1,000 rupees, but there should be no issue on it. Fix the minimum court fee that you think is reasonable, but it should not be left to a dispute. Just one liner act would do, that for every civil case, maybe 1,000 rupees, 5,000, 10,000, whatever you think is reasonable, but fix the court fee and you save millions of man-hour in the judicial system. The lawyers working on it, the judges working on it, the evidence being produced, judgments being written on it, appeals being filed, it consumes millions of man-hours in a year. So you can reduce those hours by just substituting this act through a one-liner that for every civil suit, this will be the court fee. That's the end of it. Second law, which needs your attention, is Succession Act. If we have 220 million people living in this country today, 22 crore, then at least 10 crores will have some movable property. Like somebody may have a bicycle, somebody else may have a 100 rupee bank account, somebody else may have a sewing machine. These are all movable articles which have to be inherited. For every inheritance, when 22 crore people, all of us are to die one day, then our heirs will have to go to a court to get a certificate. So if half of this population will have to go to the courts one day, that means that we are already ensuring 10-11 crore dawe. 3,000 judges, magistrates all over the country, and we are ensuring 10 crore dawas already. Is it reasonable? It's not. Why does everybody have to go to court for this? Courts are a part of dispute resolution mechanism. Whenever there is a dispute between the parties, in 95% of the inheritance cases, there is no dispute. The parties know who the heirs are and what are the shares of the heirs. Why do we have to go to court for that? So what I would suggest is that now that you have a national data registration authority, NADRA, you can give a 4-month period to the population that you can get your family trees completed by NADRA. Everybody can just go and check and have his family tree incorporated in the NADRA record. And whenever you need a succession certificate, you go to NADRA with a click button on a computer, you can get your succession certificate. It's only those 1 or 2 or 5% of the cases where there is a dispute. Yes, courts are there to solve disputes. They're not there to do a clerical job, which can be done by anybody else. So you are ensuring 10 crores of civil suits on this judicial system, which is already under great pressure of numbers. So this is the second law which I would say the government, the parliament need to attend to so that our burden is lessened. The third is the Preemption Act. Do we need Preemption Act? I think it was a thing of the past. Centuries ago, tribal people, they never wanted any outsider to come and live in their tribe or live in their territory. I think that law is no longer, it should no longer be a part of our laws. Now there is a freedom of contract. Now there is a fundamental right to acquire property and to enjoy your property. Articles 23 and 24 of the Constitution. It's a fundamental right to acquire property. Now there's a sub-constitutional legislation which says no, if you acquire, somebody else will snatch it away from you. So before we look into these laws and test them on fundamental rights, I think it's for the legislature to attend to this. Is it really reasonable? Now we have multi-story buildings in the cities. One flat owner is suing another flat owner. And this is one source of blackmail, source of fleecing money from others. It is being misused. The we were advised to look at this law, whether it has outlived its utility or not, and whether it conforms to fundamental rights or not. The other law which I would want the legislature to attend to would be the Illegal Dispossession Act. This was introduced in the year 2005, and if you ask me, what is this law? I would confess that I don't understand this law even today. We have civil courts dealing with dispossession. We have criminal courts dealing with dispossession. There are penalties provided. Everything is provided. Then suddenly this law comes, which is neither civil nor criminal. Property disputes are being decided on the basis of reports of SHOs. The police reports now determine the rights of parties in civil matters. I don't understand this law. I constituted a 7-member bench in the Supreme Court to attend to this, to try to understand what does this law mean and where does it apply. And within half an hour of arguments, all the learned counsel appearing before us, they just put their hands up, said, "Sir, we don't understand what this law is." So then we requested the learned Attorney General to apprise the government about this, that this law is again misused. Originally, there was not even a right of appeal provided. There is a term of imprisonment, punishment is provided, there is no right of appeal. Now they have provided a right of appeal only to one extent, not to the other extent. Again, there are issues. Where should people go? Should they file a revision petition? Should they file a writ petition? Should they file a petition under Section 561A? Where should they go? So far, there is no clarity. So please look into it and clarify the law that you have made before we do something about it. Then the Anti-Terrorism Act. Everything under the sun is terrorism in Pakistan, if you go by the definition given by the law. It could be the smallest of crimes, it could be the biggest of crimes, but if you look at the definition, everything is covered. A simple theft, a robbery, a murder, a rape, any extortion, everything can be interpreted in a manner that it somehow fits into the definition of terrorism in the Anti-Terrorism Act. So we have now made an effort. We have constituted a 7-member bench in the Supreme Court. The judgment is reserved, so I can't say much about it, but it was for the legislature to come up with laws which are very clear, unambiguous, easy to apply. So what I'm highlighting is that these were jobs of the legislature. The state is not just the judiciary which is to implement the laws and to give effect to them. The state itself has a responsibility to make laws which are absolutely clear and which are easy to understand and then easy to apply. One aspect I was told that I must share with the presiding officers of the model courts is the contemporaneous writing of judgment. This is an idea which I floated and I also practice on it. You see, generally the trend was that the trial courts record evidence and then they hear arguments and then a date is given for announcement of judgment. 1 month from today, judgment will be announced on such and such date. That date comes, the judge is still not ready with the judgment, another date for announcement of judgment, and a third date for announcement of judgment. That should not be the case. The model courts I have suggested is that the normal pattern in a criminal case judgment is that you give the facts as alleged in the FIR, then you say that the charge is framed and he pleads not guilty, then the prosecution evidence, then 342 statement, this is the stand of the accused, and then the arguments, the points raised, and you give the judgment. So what I proposed through this contemporaneous writing of judgment is that once you start your case, you start writing your judgment as well. On day one, you say such and such accused was produced, charge was framed, he pleaded not guilty. Then PW1, PW3, PW4, they appeared and they said this. That's it. Your day's proceedings should also be reflected in that day's part of the judgment. So second day, PW5, 6, 7 appeared and they said this. In cross-examination, they answered such questions like this. And then you come to the last stage. Then once you have already prepared your judgment as far as the evidence is concerned, then on the last day you hear arguments and then you decide. You write those last 3 paragraphs of your judgment that this has been contended before us and these are our answers to all those contentions. So the day when arguments are completed, that same evening or maybe next day, your judgment is already prepared. You don't have to adjourn a case for writing a judgment. You can start writing the judgment on day one. And this is what we do in longer cases which are argued before our courts as well, in the high courts, in the Supreme Court, that every day's proceedings, all the arguments which have been raised before us on one day, we go and start giving a dictation that this has been argued and this is, these are the rulings cited and whatever. So on the last day, when you hear the arguments, you're already prepared with the factual part of the judgment. So this is my idea of contemporaneous writing of judgment, and I understand that the presiding officers of the model courts have already understood this and they're already practicing on it, and that is why within a day or two they are out with the final judgment as well. So these are different ideas which I had picked up throughout these 40 or 50 years of experience, and I just wanted to pass it on to them, to all the coming generation. And I'm extremely grateful to all the officials who have cooperated in this enterprise, all the stakeholders, the government functionaries, the police, the prison department, the health department, the chemical examiner agencies, the authorities there, the laboratories, and most important of all, you see, many people conceive many ideas. Conceiving an idea is not really a big deal, but putting it to practice is the actual thing which requires a lot of effort, a lot of energy, and then commitment. This commitment shown to this project by Mr. Sohail Nasir, I must take his name. He is the heart and soul of this project, and we must appreciate it. And it is, but for his efforts, it could not have taken off. Then Hayat Shah Sahab, the Director General of the Academy, and without his personal interest in the matter, and not just interest, enthusiasm, he also put in his entire experiences in life, experiences as a judge, behind all this effort. He has provided the logistic supports. We have our monitoring system based here. The whole project is based in this academy. And we are very grateful to you, sir, for your effort and your support. Then we are also grateful to the Sindh High Court for providing us a team of experts in IT. The monitoring system in Sindh High Court is exemplary. I happened to visit Karachi branch registry of Supreme Court. I was holding court there, and then they were very kind to give us a presentation on Sindh High Court, how every case in the province is being monitored. There is live updates coming from, if I want to see what is Civil Judge Ladkana doing, then just click of a button and I'll see the progress as to what happened in that court today, what is happening right now, and by the evening there are results updated and the entire performance is reflected on a daily basis. Judges of the High Court monitor it. The Honorable Chief Justice of High Court supervises this. And there are computer-generated messages that the computer itself will tell the judge that your performance was not right today. It wasn't according to the normal which is required. So automatically a message is conveyed to the presiding officer that yes, you are being monitored, you are being judged, be careful, improve yourself. So we requested the Sindh High Court to provide this expertise to us, and once again very grateful to the Honorable Chief Justice of Sindh High Court for sharing all that. An IT team came and sat here for 1 week, and those systems are being followed by us today. And last but not the least, my judicial heroes, the presiding officers. I would, as Mr. Sohail Nasser said, that when this plan was being envisioned, we were discussing the nitty-gritty. I said we can come up with every procedure, we can find out solutions to different things, but the real person who is to drive this vehicle, this project to its success, is the presiding officer. I must say, I said, "Mujhe cheete chahiye, cheete." Who will pounce upon cases, who will decide cases, who will push the cases to their logical conclusion. It's the passion which is required. And I'll give you an example of a Chief Justice of Canada. He resigned this about 30 years ago. The Chief Justice of Canada resigned from his job, and in his letter of resignation he said that 20 years ago I joined this profession as a judge, and judging and dispensing justice was a passion. But now, after 20 years, I feel that that passion has gone. It has become a job now, so I resign. So we want people with passion. And now we have got 116 people of passion. And we are grateful to them, we are proud of them, and inshallah we'll add more to them. So I would request all those presiding officers of model courts to kindly stand up so that we can clap for them. Thank you. Thank you. We are proud of you. You are bringing in such change in the society, a society where justice is dispensed quickly, is a stable society. It's a satisfied society, and it progresses. You are laying down a foundation for future prosperity, future stability of the society, and your efforts will never be forgotten. So we'll keep on remembering you, we'll keep on honoring you, we'll keep on inviting you. But the next phase is that we want to, now that we have experience of about 10 days now, so after about 1 month, we would like to add one more judge to the model courts. And after every month, we'll keep on adding one more judge till all the judges start functioning as model judges. And for that, I will suggest that the second edition should be on the civil side. We should also, as suggested by all these honorable speakers, the honorable Chief Justices, the next model court will be a civil model court, and for that the priority areas should be the most urgent cases, which are family cases, the rent cases, and then we can build on that, go over to other cases of grave importance. Thank you very much for your effort. You came all the way from all parts of the country, and once again thank you all the officials who have cooperated with us. This cooperation should continue, and we'll remain ever grateful to you. Thank you very much.